before us today, and that is Ward versus Cuyahoga Falls Board of Zoning. Both sides will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes. You're ready to proceed. Sir, if you wouldn't mind introducing yourself and then telling me if you'd like to save some time for rebuttal.
Yes. My name is John Ward. The address in question is 2774 Bailey Road, Cuyahoga Falls, Ohio. And I would like to reserve some time if possible.
Okay, thank you.
The reason we're here today is to appeal the decision of the lower court based on a shed structure that I had built at the property of 2774 Bailey. The height, I know, has been taken out of it. I included part of it in my brief due to kind of the build-up to this case. The biggest problem that I had with this entire process was the fact that a lot of information that I had submitted to the Board of Zoning never actually made it into the official record. And the lower court, in my opinion, erred by not allowing it to be admitted to be taken into consideration when it was up for an administrative appeal. I know Ohio Revised Code 2506.03 states in part, it appears on the face of the record or by affidavit, that the record is missing evidence submitted by the appellant at the hearing. And that really is what applies in this case. There's numerous places within the actual transcript that was submitted that proves that there was documentation that was being addressed at the board meeting, but otherwise was not actually in the transcripts. On page 10 of the BZA transcript, one of the board members, Tom Sullivan, was commenting on the extra papers that were there. I know, I'll see on page 5, Tom Baldwin was addressing missing emails on the height, which actually correlates with appendix page 14 of my brief, was the actual email that he was addressing. Page 57 of the BZA transcript addresses additional documents for the board via an email. Let's see. A15 of my appendix under my brief was an email that addresses the meeting on the side roof and the removal of a small shed, which was not taken into consideration as far as the calculated square footage that the city is saying that we are over. Let's see where some of the other ones were here. All right, part of the other issues that I had, I know once I received the actual transcript, from my memory from the first meeting that we went to, there were certain things, one phrase in particular, that I never found in there to where I thought that the transcript was slightly paraphrased. And that was one where Mr. Sugar with the city zoning department had made a comment that the county would not have approved any permits that the city had not already approved, which was part of what backed up my case, where once I got the proper permit from the city, it was sent to the county for approval. And if you look through the transcripts, you will see on there where under the application with the county, it has the square footage of 1,040 square feet. On the application itself, it has listed where it was with a side roof. So I was always under the impression that it was included with this project. Once we got to the second board meeting, I know in regards to the height, just seeing how things had flipped a little bit, it was on page 30 of the BZA transcript, and I apologize, let me get back to the first board meeting. Again, Mr. Sugar had stated with the board that there was no steep grade changes on the property with the height issue at the time. But then during the second meeting on page 7 of the transcripts, he's quoted as saying that the property does slope a little, where it just shows that there's a change in the facts, basically. I know the lower court did rule that the height was okay because there was enough proof, even with what was submitted with the transcripts, to justify that the city had already approved the height. But as far as the side roof, again, that was always included in this project. I never knew of it not to be, and with all of the documentation that you'll find in the appendix of my brief, you will see everything in its entirety that shows from the first time I went to Home Depot and had gotten the brochures and the estimates and breakdowns. All of that is in there, which shows that there was a lean-to style roof on there. I know the city has emphatically wanted to call it a carport, but by the city's own definition per the transcripts, the BZA transcripts, it is not a carport. It was never designed or built for a carport. It is not used to house any kind of a car under. And to further add insult to injury, the same type structure that they are claiming is illegal for me, they did allow one of my immediate neighbors to build the exact same type of structure, which you will see under appendix page 30 of my brief. That was done in the spring of 2015. When I called to inquire about it, I was told that they had changed the wording on that to call it a covered patio, where mine they wanted to refer to as a carport. But then, even during the one of the meetings on page 31 of the transcript, you'll find where Tom Sullivan, one of the board members, refers to what I have as a covered porch. So, I tried to utilize the city and all the resources that I could, because I do not live here. I live out of state, and for the structure that we were building, I relied heavily on the information I received to try to make sure this was done by the book, to the letter, to avoid any potential problems or issues. With everything that has transpired since then, it has been nothing but a constant fight and battle to try to get this rectified to where I can keep what was actually built. I know there was one email that I did receive that I had gotten. It was in November of 2014 that was basically contradicting the questions that I had in regards to the side roof. But I did not receive that email until actually about a week after the structure was already completed. And when I went back through my emails, trying to look through it and even corresponding the times, the city's email in rebuttal to mine was sent about, I think it was 40 minutes before I actually even sent mine, making it look like the emails had somehow been tampered with. I don't know that. It's just how the appearance was, and you're welcome to look at them. They are in the transcripts. And that's basically the case that I have. Again, I encourage you to look over everything as far as the transcripts and the brief to correlate, so you can see where I'm coming from with everything on mine, because I was under the mindset the entire time that what was built was exactly what I have on my property right now, that it was proper. One thing the city will probably address is the actual color of the structure. I have agreed to paint the structure before. With the way that the city's position is flip-flopped, I prefer to keep it the color that it is. I did get a verbal approval on it by Mr. Sugar when I stained it, and it was done in February where it was too cold to actually paint. I would prefer to actually keep that color, but that's a relatively minute issue with me. The big issue is to be able to keep the structure the way that it is with the inclusion of that side roof. So, thank you.
Thank you. You'll have 5 minutes remaining.
All right, thank you.
You may proceed.
Thank you. Good afternoon. My name is Janet Ciatola, and I represent the city of Cuyahoga Falls in this matter. Also with me today is Matt Dickinson and Nick Sugar, our zoning inspector. This case came to the attention of the city when neighbors called to complain about violations during Mr. Ward's construction. As a result, the city had to issue a stop work order on the construction, and subsequently the appellant requested various variances from the city, 2 of which are at issue here. The city is not, as Mr. Ward had indicated, is not contesting the height variance for the shed. However, the city maintains the trial court correctly determined that Ward needed to remove the additional carport or lean-to attachment on his shed and to paint the shed to match the style of his home. The first variance he requested was to allow a carport on the side of the shed, and the city's code of ordinances specifically prohibits such structures. The second requested variance was an expansion of the amount of square footage allowed to be covered by accessory buildings. The property in question is allowed a total of 1,350 square feet for all of its accessory structures. With the shed in question and the carport, the property has substantially more square footage, i.e. 1,740 square feet covered with accessory buildings. Additionally, based upon his filing with this court, the board now is taking issue with the zoning appeal board's ruling that he paint a shed. It's important to note that he agreed to paint the shed at the zoning appeals board hearing and even indicated his willingness to do so on his initial application for a zoning permit. The two assignment of errors, the first one is Mr. Ward seeks to bring in additional evidence not set forth or provided at the Board of Zoning Appeals. Mr. Ward claims that there are certain documents that are missing from the record of proceedings, and I will assure the court that the record of proceedings is all of the documents that he offered as part of his case were included in the record. Nothing is missing. Additionally, much of the evidence that he seeks to now produce is newly discovered evidence that he acquired way after the administrative appeal of this matter. And I would indicate that even if the lower court had considered these photographs of other purported carports in the city, it would not have reached a different decision. The General Development Code in the city of Cuyahoga Falls did not preclude carports until 2005. So some of the additional evidence that Mr. Ward has brought forth are of carports that have been grandfathered into the current regulations, or perhaps are currently under orders with our zoning department, or are not carports at all. So city maintains that the trial court was correct in confining the transcript to the record of proceedings below. Secondly, the city maintains the trial court did not err in determining that the Board of Zoning Appeals decision regarding the carport and painting of the shed was supported by a preponderance of reliable, probative, and substantial evidence. The variance requested in this case is an area variance, and Ward had to show the board that the excuse me. To obtain an area variance, Ward had to show the board that denial of his request would cause impractical difficulties and that the variance would otherwise not be contrary to public interest. Considering the transcripts, the record of proceedings, and the court's ruling below, Mr. Ward has not shown practical difficulties. The practical difficulty would have been avoided if Ward had built the structure according to plan. Despite his assertion, Mr. Ward never included a carport or a lean-to structure in his initial plan. It was never approved by the planning department, nor was it ever approved by the Summit County Building Department. And therefore, the denial of his variance on this matter is really self-inflicted. Secondly, Mr. Ward already has a variety of accessory structures on his property that he could use as storage. He has the shed that he has recently constructed, and also he has a 2-car garage that he could store the additional materials that he seeks to store. Thirdly, as the trial court correctly concluded, the carport lean-to structure significantly exceeds the allowed square footage in the city of Cuyahoga Falls. And additionally, carports are not permitted within the city. Accordingly, the variance would not advance the spirit and intent behind the zoning requirement, and substantial justice would not have been served by the granting of this variance. And for these reasons, the city of Cuyahoga Falls respectfully requests that this court affirm the lower court's decision. Thank you. Excuse me.
That's okay. I was going to offer you my water, I haven't done that's awful.
I'm on like 3
It's dry.
minutes.
Yeah, I'm same way.
Thank you.
You're welcome. You do have 5 minutes for me if you want to.
All right, just to briefly touch on a few of the points she made, there was a stop work order that was issued, however, after the shed was actually completed, with the exception of literally a few rows of shingles. But otherwise, the shed had been completely done. Once again, this is not a carport. as the city wants to address, and looking at the information that I have provided, you'll find that it is not a carport. Every aspect of this, from every piece of information from Home Depot, Classic Manor Builders, it has never been referred to as a carport by any other structure.
Isn't what she's arguing is that it's not so much the structure as much as it is that you've exceeded the square footage that you're allowed to have covered?
That was partly after, initially it was a carport, and then it was that it was over on square footage. With that, when I met with Mr. Sugar, and this is where the mistake ended up happening, I went to his office, we sat down. I was told we could have 1,350 square foot of out parcel space. It wasn't total of 1,350, it was an additional 1,350. That's where the mistake got made. And if you look through some of the emails that I have provided, you'll find on there where the structure that I originally wanted to build was the main shed structure with a side roof on the right-hand side, the left-hand side, and one in the rear. But due to those square footage constraints, we removed the one on the right, we removed the one in the rear, and only kept one to conform to that square footage.
Were all those emails in your original,
Yes, ma'am.
they're already in transfer? The stuff you've added on here, isn't anything that wasn't already there before?
That I would need to double check. That might be something that was omitted. I would have to double check on that with the emails, but I know the city had provided a lot of the emails initially.
Anything that you've added here that wasn't provided before, we're not going to be able to consider.
Correct, and I do believe those were actually in there. Let's see. Also, when she was addressing about all of the papers being in the transcript, if you will look at the transcript, page 5, again, with the one board member was addressing an email that was never included in the transcript, and that was specifically dealing with the height, and that is one that I did provide that was not allowed with the lower court. So, I mean, there is plenty of proof in the transcripts that show the information that I was addressing at the meetings were not actually in the official transcript. They were missing. Also, the pictures that I had submitted, they weren't so much of the carports as they were of similar type sheds, not so much in size, but in the type and also in the color, where they weren't painted or stained to match the actual dwellings. Those I had included in there just in support of the fact that I would prefer to keep mine stained. And there was some that I did provide earlier that did have carports in them, but I never did have the information to corroborate it as far as the actual dates. And then the other aspect is, if y'all will pay attention to page 54 of the BZA transcript, and do y'all have that with you today?
No.
Okay.
Well, don't worry, we will go through it with a fine tooth comb. You can
Well,
tell us
on
what it says.
page
and we can look at it.
54, there is a picture that was submitted to Mr. Sugar with the zoning department. Get your magnifying glasses out when you go to look at it, because it has been compressed so small that you cannot really see the picture, you cannot make it out, nor can you read the handwritten text that was sent along with it. If you will look at appendix page 10 of my brief, that is the actual email that was sent, but was shrunk so small that the board members could not even see it to take it into account, let alone the lower court. There is plenty of information with this, and I don't like calling out other people, but I do believe there was a lot of impropriety on the city's behalf to suppress a lot of the information I had once this started to become an issue. Because I do know the height was initially approved beyond what the city code was, so technically, even though it was an exception that was made, it was actually legal from the original approval. So, and that's about all I really have to add to this.
Well, thank you.
Thank you.
Thank you both for your presentations to the court. The court will take the matter under advisement, and we will issue a written opinion that rules on the matter, and it will be sent to both sides. And then you can also check on our websites on the Supreme Court as well as here on the Ninth District Court of Appeal website. So thank you.
Thank you.
Thank you.